Nader, how are you?
I'm very good. I'm so pleased to be back.
Well, I'm very happy to see you. It's been a while since we last saw each other or had a chat, but we have a lot to talk about today because you wrote actually a very interesting opinion piece today, the Globe and Mail, that I read this morning first thing, and I'm like, okay, I have to call Nader and we have to talk about this because it really reflects some of the recent frustrations that we've been feeling in the legal world. And well, I'll let you talk about your opinion piece and then I'll ask you a bit more questions. But tell us about this piece that you wrote today.
Yeah, I felt compelled to write this opinion piece on the importance of judicial independence. I was a couple of weeks ago, I was sitting at my son's baseball game, and I'm looking at my news feed, and I'm seeing all of these comments, increasingly troubling comments from Doug Ford, criticizing judges. And I want to be clear, there's nothing wrong with criticizing the correctness of a judge's decision. I do criminal appeals. I criticize judges' decisions all the time. That's part of my job. But there's a difference between saying a judge got it wrong and appealing that decision on principle grounds on the basis of the law versus doing what Doug Ford has been doing lately, which is undermining the judiciary by suggesting that judges' decisions are illegitimate or that they're politically motivated or that they're making decisions from a place of weakness. He's used the term weak-kneed judges a number of times when he's talking about bail reform and judges allowing people out on bail. And that kind of rhetoric is so dangerous in a democracy because it undermines respect for the judiciary, which is fundamental to upholding our rights and freedoms. The other thing that's concerning is that the Doug Ford rhetoric and other populist and right wing politicians in Canada today, the way they speak about judges and the judiciary, it is so reminiscent of the comments that Donald Trump has been making now for years south of the border in criticizing judges who either rule against him or rule against causes he supports. Again, it's not criticism of the reasoning of the legal reasoning of the judges. It's criticism of the judges themselves and of the very institution, and suggesting that judges are just partisan animals, which of course is fundamentally not what's happening, at least in a place like Canada, where we do have a tradition of judicial independence. And again, I'm not saying all judges are perfect. I'm not saying that judges always get it right. They don't, but we have a system of appellate review. And that's the way to challenge a judge's decision, not to sound off at a press conference, calling judges weak-kneed or bad or suggesting that they need to be elected, which Doug Ford recently said. So I thought those comments were really troubling because number one, they're so similar to the vicious vitriol that we're hearing from the U.S. president, and secondly, we know as criminal lawyers that our rights in this country, they exist only on paper unless we have judges who are willing to uphold them. And having judges who feel confident and secure in their ability to do their job is really important. And with the dangerous kind of rhetoric that Doug Ford and other politicians have been spewing lately, that undermines the judges' ability to do their job, and that's why I was so concerned.
And well, here's the issue though. There are a lot of people who support Doug Ford and who agree maybe with this idea. So that, yeah, we should have judges who are elected and who endorse or who think in a particular way because that's our view.
Yeah.
And unfortunately, or I don't know, fortunately maybe, but we're seeing a bit more of that, as you mentioned, as you wrote in the opinion piece, that we're seeing more of that in other countries, especially in the US. So the difficulty as well is that there are some people who may not have an issue
Yeah.
with this. And What is your view on that, Nader?
Yeah, I mean, I think that's all the more reason to talk about it, right? That's all the more reason to talk about it. We as lawyers take these values and these principles for granted. And I think that's partly because we understand their importance and their place in our democratic society, and why judicial independence is so important and why it's not to be interfered with. We understand that because we are consumers of the courts in our daily work. Um, Other people may not have that same understanding, and so it's incumbent upon us to help educate other Canadians who may not have a legal education, who may not have an understanding of the role of the judiciary in our constitutional democracy. I think sometimes as lawyers we have a tendency to be a little bit insular sometimes and say, well, look, those folks, they don't know what they're talking about, and just disregard them. We can't really do that. It's not fair to them, and their misunderstanding may come from a place of genuine misunderstanding rather than malevolence. So rather than ignoring folks, I think it's incumbent upon on lawyers, and lawyers more than judges, because even though I'm talking about judicial independence, judges, they can't go out and write op-eds. They can't go on your show. They can't go on talk shows and give presentations and speak in the same kind of off the cuff way that we can. Judges have to be very mindful of their role, and so they're constrained. So it falls upon us as lawyers to explain to the public why judicial independence is so important and why it's not to be interfered with lightly.
And yet, in your op-ed, you do mention something that did happen that was very unique, is that the judges did actually write about that because I think they were very provoked by these
Yeah.
comments.
Yeah. Yeah, I mean, you're referring to, it's this doesn't happen very often,
Mhm.
where the Chief Justice of each of the Court of Appeal, Superior Court, and Ontario Court of Justice, they issued a joint statement on the importance of judicial independence. And they didn't call out Doug Ford by name, but the statement has come in the wake of some of these comments. I think it was pretty clear who they were speaking to, or
Yeah.
who they were at least directing their comments to. And that's very unusual, as you point out, for the judiciary to speak extrajudicially like that. Ordinarily, judges speak through their decisions, and then that's another reason why it's a little unfair for politicians to be taking cheap shots at the judges like this, is because they know that the judges can't respond.
Yeah.
They speak through their decisions, and then they wait for the parties to appeal their decisions to the higher court. And that's the way it's supposed to work. And Doug Ford and politicians, they have no excuses. I mean, some folks, they may lack access to justice. The poor, the marginalized. I mean, that's a separate issue that's worth talking about, access to justice. But Doug Ford doesn't lack access to justice. If he doesn't like a decision that's rendered by a judge, if he doesn't like the decision that Justice Chavis rendered about bike lanes, he can appeal that decision. And he's got an army of lawyers at his disposal. Some of them are extremely good, and they can appeal that decision to the Court of Appeal and argue why Justice Chavis got it wrong.
But
And
then
then the Court of Appeal will decide.
that's the thing. Like, if there are some other avenues, there are other ways, like if he's not happy with that, but then why is he insisting on that? So how important is the role of the judge then? Like, it begs the question, like how, like it just means that the role of the judge then is really very important, because if there's this insistence on really trying to control how the judge is going to decide and the decision and everything. So there's this fear that we want to make sure that the judges are rendering decisions that are the way we want them to be, that we agree with them, that we like. So why is there this concern? So how important really is the judiciary in the system?
Yeah, I mean, the reality is that, look, we have this wonderful document, this constitutionally entrenched Bill of Rights called the Charter. It's a beautifully written document.
Yeah.
But you know what? In Russia, they have a beautifully written Bill of Rights in their constitution too. But the reality is, because you don't have an independent judiciary in Russia that gives effect to those rights, that document has very little meaning. And that's how it works in a constitutional democracy. The rights and freedoms that we are supposed to have, that we're constitutionally entitled to, they exist only on paper unless you have judges who are willing to enforce them and give them real effect. And so that's why the independence of the judiciary is so sacrosanct and important, and why we as lawyers need to be so vigilant against interference with that judicial independence, because we can't have judges out there being afraid of what Doug Ford is going to say or what the Globe and Mail is going to say tomorrow. If they're afraid of that, then that compromises their independence and they can't do their job. And we as Canadians will suffer. Maybe not the people who aren't before the courts, but when people are before the courts, then all of a sudden they care about their rights and their freedoms and due process. For some folks who haven't had the misfortune of being in the system, having gone through that, it may seem a little bit abstract and difficult to comprehend. But how many clients have you had? Family members of clients who say, I used to be really pro police and pro government until this. Well, that's the reality for many folks. Until they're in the thick of it, it's hard to understand just how sacrosanct and important these rights and freedoms are, and just how important it is to have this neutral arbiter out there who doesn't care what the politicians say and who's going to do the right thing and enforce those rights if you have a good faith claim to that right being enforced.
Right. And what we're seeing here is that there seems to be a disregard for these charter rights on the part of the government, that it's like, oh, these rights, they seem to be an obstacle, right? They're annoying, they're an obstacle in the way of some projects or whatever interest that the government has. But then I think the other frustration is that it just feels sometimes that even members of the public don't realize how important these rights are, right? Because I don't really feel that there's a lot of a pushback from the public, that or that there's an outrage. It seems like it's only defense lawyers who are outraged the most, but I don't feel like a lot of people really care about this issue as much as we do. But that's a bit concerning as well. I find, like, why don't people realize how important these rights are?
Yeah, I mean, I think it may not be just defense lawyers who are concerned, but you're right. There it is concerning that there is I'll say a loud minority of folks who seem to think it's okay to ride roughshod over rights in pursuit of some partisan agenda, and that's troubling, and that's all the more reason to help educate our fellow Canadians on just how important constitutional rights are and why they're important, and why they're necessary for the long-term functioning of a free and democratic society. As I said, like, I don't think we can afford to throw our hands up and say, hey, these folks are misguided. I think it's on us to continue the dialogue and explain to folks why they're just so important.
And what do you think should be done? I mean, I know you're doing your part, like you wrote this opinion. First of all, like, um, I'm guessing it came from a place of frustration, right? Like it was really
Yeah, I mean, it came from a place of frustration, and also I think also from a place of fear,
Mhm.
because democracies are fragile, right? I mean, we take them for granted. Who would have predicted that the United States, the birthplace of modern constitutional democracy, even 15 years ago, who could have predicted we would be in the place we are today, where there is, I would suggest, very little regard for the rule of law. I mean, there was a recent, I reference in the op-ed piece, a study that was done by the Washington Post, where the Washington Post had done an analysis of 165 court orders that had been issued against the Trump administration, and the Trump administration had disobeyed court orders in approximately 34% of the cases. That is unheard of in a constitutional democracy. We take for granted that when a court issues an order against the government's going to comply because that is what it means to be a society governed by the rule of law. And this is what's happening south of the border. And long before the Trump administration was disobeying court orders, Mr. Trump was speaking disdainfully about the judiciary.
Yeah.
And so, I am fearful that this disdain, this contemptuous approach to the judiciary is a harbinger of things to come. We don't have a constitutional democracy if the executive doesn't respect the judiciary. That's the problem in the United States right now. That's the problem in more extreme autocracies, like Russia. But in order for there to be rule of law, it's not just that the citizenry must follow the rules. Government also must follow the rules, and that means an acknowledgement that the Constitution is supreme and not the elected government of the day.
And the government sets an example. If the government doesn't respect the law, why would a normal citizen respect the law? I mean,
Yeah.
I don't get it. But so then what can be done here? And this like I mean, because I mean, you said that there was also this fear, but it is scary. It is scary
Yeah.
once we start hearing this rhetoric coming from the government that, oh, like we should. But how can anything be done? Is there anything that can be done? I mean, um, to stop this from going where it could go?
Yeah, I mean, firstly, I think there needs to be political blowback for politicians who speak like this against the judiciary. I think there needs to be a reckoning, and I think part of the reason why folks like Doug Ford continue to make these types of comments is because they think they can get away with it, and they think it plays to a certain base, and that's maybe that's perhaps a cynical view, but I believe these politicians are behaving cynically when they're willing to do long-term harm to our democracy in order to score some cheap political points. So I do think there needs to be a cost for the politicians who are undermining democracy in this way. So I do think that it's also on the opposition out there to make more of this kind of thing and explain why this is not just politics. This is undermining the very fabric that makes us a free and democratic society. So I do think we ought to be making a bigger deal of this kind of thing rather than just be like, oh, that's Doug Ford being Doug Ford, oh, that's Donald Trump being Donald Trump. Yeah, they're being themselves, but they're also being extremely dangerous and harmful to democratic values.
I totally agree because if we look at the state of criminal law in general in the past few years, I mean, we've lost so much on the defense side. Like the prelim has been
Yeah.
considerably reduced. It's very difficult now to have a prelim. And in the few cases where we do have a prelim, crowns keep directing the
Yeah.
indictment. So it's almost non-existent anymore. Uh, there are tougher laws in bail. In sentences are becoming harsher. So it is really scary. I mean, if we put everything together, it's not just this area. There are
Mhm.
several areas, especially in criminal law, where it's really the defense side that's suffering, and which means by extension, our clients. Um, and I mean, the question again is like, where does this end? Is there like you say, like there has to be some pushback. Someone has to say something, but it is scary because it just feels like it keeps on getting worse and worse and worse, and there's nothing to stop it. So what can we do, Nader?
Well, I mean, look, it's never going to be popular for a government to campaign for criminal accused rights. So, I mean, there's always, whether it's a liberal government in power or a conservative government in power, no one's ever going to campaign on, well, let's give the criminally accused more rights or better treatment.
But why though? Let's
No,
just,
but that's because people do not fundamentally understand why you protect all of us when you protect the rights of the accused, right? That's not something that is easy for non-lawyers to grasp. But again, I come back to the fact that this is why we have to continue to educate folks out there about why these things are important. I think this underscores the importance of the defense bar being vibrant, being united, and being forceful. And organizations out there like Wicked, like the CLA, they need to be speaking on these issues, not just occasionally, not just politely, but all the time, and keep it within the public discourse, because if we're not doing it, no one else will.
yeah. And I agree. And I think that's why I was very happy to read this op-ed this morning because I was very, proud that there was, someone from the bar who was just writing about this because I think this is how we as lawyers can do something. It's by writing and showing that this is not right. So it's I really like this piece, and that's why I really wanted to talk to you about this today, Nader. But this is not the only good thing that you did. You recently also won a huge case at the Supreme Court, a very rare kind of case to win at the Supreme Court. Well, it's difficult on the defense side to win at the Supreme Court, but this is in a very like an area that we hardly see a Supreme Court case in the area of youth criminal justice, and you won the case of IM recently. I actually will be posting an interview, a legal analysis from Justice Rock Jones and Emma Rhodes, who are very knowledgeable about the area of youth criminal justice. But it's very nice to hear from you because this is your case and you won this case. So first of all, congratulations. This is an awesome case. Really good job. It was a very good decision, I think, and I think many of our colleagues agree with that. I know Emma Rhodes was really fangirling over this decision, and everybody was excited about it. But I would like you to tell us a little bit more from
Sure.
your perspective about this case.
Yeah. Yeah, well, first of all, I'm definitely going to tune into the interview with Emma Rhodes and Justice Brock Jones, who are two of the real experts out there on youth criminal justice. So I can't wait to listen to their analysis. And thanks for the kind words about the IM decision. It was a real team effort. So shout out to my co-counsel Stephen Aylward and Alexandra Hine, who did a lot of the work on this case. Yeah, no, this was a really important case. As you know, it is very hard to get leave to appeal to the Supreme Court. It's the numbers hover at around 5%, and it's even rarer to get leave to appeal on a sentencing case. So when we got leave, we were really excited because that meant that at least one or two judges up there in Ottawa in the big house thought we might be onto something, and really the genesis of this appeal goes back to the DB case that was decided back in 2008. And you will recall, Maya, and your listeners will recall that there was a constitutional challenge to an earlier provision of the YCJA that created these presumptive offenses.
Yeah.
So that if you were 16 or 17 years old, so still a youth, but at the higher end of youth as it's defined in Canadian law. So if you were 16 and 17 years old and you committed one of several serious offenses, like murder or manslaughter or aggravated sex assault, then there would be a presumption that you would be sentenced not as a youth, but as an adult. And it would be on you as the youth to disprove that presumption. Now, that went up to the Supreme Court in 2008 in a case called DB, and the Supreme Court struck down the presumption because, of course, that reverses the burden of proof,
Yeah.
and it also deprives the young person of the presumption of diminished moral blameworthiness, with which Justice Abella, writing for the majority, found was a principle of fundamental justice. Okay, so that's great. That was a good holding back in 2008. When we were pursuing this appeal, one thing that we noticed, and it was an error that was replicated in IM's case, is that although the Supreme Court had issued its ruling in 2008, and although Parliament had amended the YCJA to be in compliance with the DB ruling, many trial courts and many courts of appeal were continuing to apply the test from pre-DB.
Mm-hmm.
So even though the Supreme Court had declared this was the new law, in determining whether to sentence someone as an adult who was 16 or 17, the courts were continuing to apply the pre-DB case law and the pre-DB tests. And we said that was, leading to wholesale error across the board. And that's why the Supreme Court should take a look at this, and which they ultimately did. And who is that having the biggest effect on? Well, in a huge number of cases involving youths who are indigenous or racialized folks, those youths are in a grossly disproportionate way getting adult sentences. So this was having a real profound effect on some of the most marginalized youths out there who are routinely being sentenced as adults instead of youths, and are not getting the presumption of youth. And the way that the test was being applied was also somewhat haphazard across the country. So this case was important in terms of clarifying that no, the onus has to rest with the Crown throughout, and it's an onus that has to be discharged on a beyond reasonable doubt standard. And that was a really important and critical question. The presumption that has to be rebutted is that this person does not have the immaturity of a youth. They have the maturity of an adult, and it has to be on the Crown to prove that the young person has the maturity and moral capacity of an adult. And our point was that, look, this is a factual inquiry. It may be a somewhat complicated inquiry. It may involve expert evidence. It may involve expert psychiatric and psychological evidence, but it is a question of fact whether they have adult level maturity, and it ought to be on the Crown to prove that on a beyond reasonable doubt standard. And we said that that is the logical application of what the Supreme Court held in DB.
And it should be difficult because
Sure.
I mean, once the section applies, it has tremendous impact on the life of a youth. So it should be very, first of all, rare to invoke this section and to apply it, because it's devastating once it does apply, because adult sentences are much more significant than the youth ones. So the test should be harder, and the burden of proof should be beyond a reasonable doubt, because it is a very like significant and important thing. Like it's something that should be hard for crowns to prove.
Right. One of the it's interesting you should say that, Maya, and I agree. But one of the criticisms is like, oh, now it's going to be really hard for the crowns to get adult sentences in these youth cases.
Yeah.
And you're entirely right. It should be, right? We should be sentencing young people as young people most of the time. And it should be the exceptional case where we're sentencing a young person as an adult. And the problem with how the test was being applied um, up until now had been that the opposite was true. It was becoming almost routine that in cases of serious offenses, that the young people were invariably being sentenced as adults, especially if they were indigenous or racialized. And that's a real problem.
Yeah. I mean, honestly, like this is again, congratulations. It's really a very important case and it's a great result. And like I said, there will be an interview where there's a full analysis on that as well. But I still wanted to hear from you, Nader, because obviously it's your case and it's an excellent job. I mean, this is not the first time that you do something really amazing, and you're known for being an excellent lawyer, and especially in these complex cases. So this is just another example of your excellent work, and this compensate for Sharma that like that. I know
Yeah,
because
open that old wound.
oh, but still, oh, but it's Sharma. I mean, I know you take it as a wound, but the reality is it was a very interesting argument that you made, a very rare argument, and it's very nice. And that again shows, just to the point that you're really a leader in the field because you will do things that other people don't do or that more people should be doing of. And that's why I admire you so much, Nader, because you have the courage to write about the things that you see are wrong and that somebody has to speak up and say something. You're going to make arguments, even if, nobody has or not a lot of people have tried to do these arguments. So these are really what defense lawyers should be doing. We should be doing these things, making these new arguments, and writing about the things that we think are wrong. And I hope more and more defense lawyers will follow your lead. So it's
Well, thank you so much for those kind words, and thank you for all you do with this podcast and all the great work that Wicked does in making these issues more accessible to lawyers and non-lawyers alike, and bringing these issues to the fore so frequently.
Thank you so much, Nader. I won't take much more of your time, but it was really very nice to chat with you. And I hope to chat with you again soon and see you soon.
I hope so too. Have a
Yeah,
great evening.
you as well.